Okay, on to our theme. What I'm going to talk a little bit about is how to regularize the existing use of a property. And the most common example of this is where you see a property and it's converted to flats. Someone has converted the building into flats, say, and there's no planning permission anywhere for it. It's been used as such for many, many years, but because there's no planning permission, it's difficult to get a mortgage on it, and it's impossible to sell those flats as individual units. It just can't be done. So the trick is, if you can buy it cheap and regularize that planning permission status, then you're going to add a lot of value to that property, because you can remortgage each flat separately or sell each flat on. Has anyone come across this situation? Has anyone seen, what sort of things have you seen, Adam?
Only things that have been, like you say, 2 flats, 3 flats, 4 flats, where they've been done not necessarily to building regs.
Yeah.
The paperwork's not in place, and they generally trade at a pretty good discount.
Now, I find that the most common place you find these things are auctions. You also see them languishing around estate agents, often not selling for several months or so. What I find, if a property does not have planning permission, you can bet your bottom dollar it's going to be cheap. It's going to be cheaper than if it had planning permission for its existing use. The other thing is that you may have a property, and for whatever reason, it doesn't have planning permission for the use that it's got. If that's your scenario, and you meet the criteria, it is also worth regularizing the planning status of the properties you've already got, because then it's worth more. It can be remortgaged or sold as individual units. This is I see these all the time. This was at the last Auction House London sale. This is a classic scenario. A lovely building, massive building in North London, 9 flats, all rented and tenanted, but no planning permission. Often you find that the vendor needs to sell for whatever reason and hasn't got the time to go through the regularization process. It doesn't mean that it can't be done. It means they don't have the time. They bung them in auction, they get a quick sell, they need their money for whatever reason. Now the trick is, what you've got to know is, before you go along and bid for any of this stuff, can you regularize the permission? And that's what I'm going to take you through now, the steps that you need to follow so that you can know with some certainty, before you even buy one of these things, whether or not it fits the template for getting the planning status regularized. Now, failure to obtain planning permission in the first place is actually not an offence. What is an offence is not complying with an enforcement order to correct a planning breach. There are all sorts of people, for all sorts of reasons, have not got planning permission for a use or a change to a property. That act in itself is not the offence. If the local authority serves an enforcement notice, failure to comply with that then can turn into an offence. But the thing is, there are strict time limits in place for the local authority to serve enforcement notice. And if those time limits expire, the local authority cannot take enforcement action, even if you did not have planning permission. But it's in some kind of limbo land status. So let's say someone converted a building 6 years ago. It's converted into 4 flats. Although the local authority can't take enforcement action, you're in this limbo land status that they can't take action against you, but it's not mortgageable because you don't have planning permission for it. But if you can meet certain criteria, you can get retrospective planning permission for that usage. And this time and time again represents a fantastic opportunity to add value to a property by a 3-month process and a little bit of paperwork. Now, I want to take you through these time limits. I'm trying to not kind of bore you too much with a ton of regulation stuff, and I'll give you a couple of books to read if you're interested in this stuff. Because the thing is, it is dry. But what I find with property is you've really got to get clued up on the law. You've got to know what you can and can't do in law and make sure that you exploit all the opportunities within the law to profit from the wonderful game of property. So, time limits. Under the Town and County Planning Act 1990, the local authority have 4 years to take enforcement action on what is called operational development. Now, to kind of summarize what operational development is something material. So if you build an extension on the back of your house without planning permission, that is an operational development. And they've got 4 years to take action against you from the time that development is substantially completed. If it's a change of use of a property, then the time limit is longer. It's 10 years. The reason for that is roughly to do with operational developments are sort of external and obvious, and in lot of change of use stuff is internal to a building, and so that's why the Act allows local authorities a slightly longer period to take enforcement action. Now, it's important to know this, because a lot of councils get this wrong, because a lot of planning officers and enforcement officers don't know the planning law. I mean, I'll just sort of, there's no way of sugarcoating that. And it's quite easy to be a little bit more clued up on the law than a lot of planning officers. And there's plenty of case law on this. A lot of planning officers think that a conversion of a dwelling into multiple flats is a change of use. And they think that it's the 10-year enforcement rule. But that is not the case. Case law says that a change of converting a single house into multiple flats is an operational development, because you have to, by making self-contained apartments, you're making a material change, which is an operational development. And that's actually defined in the Planning Act. So flat conversions are subject, as long as you're making self-contained flats, they're subject to the 4-year rule for enforcement by the local authority. HMOs, on the other hand, if someone has built a sort of large HMO, so if you build an HMO of more than 6 bedrooms, you need planning permission. So let's say someone has built a 10-bedroom HMO. If the local authority can take enforcement action to convert that property back into a single dwelling, if it's not done with planning permission, and they catch up with it within 10 years, that's the enforcement limit for that. Yeah? These are the two big things that it is very, very hard to pick up a large HMO without planning permission and actually get all the evidence in place to show to the local authority that it's been used as an HMO for 10 continuous years. It's much easier to do this one at the top. Does that make sense to people so far? Now what I want to share with you is a little checklist, because you can buy these properties, but you only want to buy them if you can have some certainty that when you apply for a certificate of lawful use to regularise the planning permission, you're actually going to get it. And the first thing to check is whether the local authority have issued any enforcement notices in the past. Because if it's already on their radar, then it ain't going to happen. You find this information out. If it's an auction purchase, you will find this information out in the legal pack. Because in the legal pack, you have the local authority search. And inside the local authority search, you will see the planning records, and it will say whether any enforcement notices have been served on the property. If an enforcement notice has been served, then it's on the radar. Things are a lot more difficult. If it's not an auction property purchase, and it's through an estate agent, you still need to find out the planning records. You won't get these online. The easiest way to do this is to go down to the local authority planning office and ask to inspect the planning records for a particular property. They're public information. Set up an appointment, go down and see it, view the planning records for that property, and see whether enforcement notices have been served. Then what you're looking for is whether you can show that, let's say I'm buying a block of flats. What I need to be able to demonstrate is for the last 4 continuous years, it's been used as 4 flats. And I need to evidence that. If there's a break, a substantial break, that's a problem. I was looking at a property last week in Highbury, actually. It's 5 flats in one building, no planning permission. But it's a messy sale because it went through probate and there was disputes among the family members who were inheriting it. To cut a long story short, the property hadn't been occupied for nearly 2 years. That presents a problem because the evidence you need to demonstrate is that it's had 4 continuous years usage as 4 flats. Yeah? So remember I showed you that auction example right at the beginning? That was textbook because you buy it, it's already tenanted, it's relatively easy to show the 4 continuous years unbroken usage. Okay, so what you need to do is gather the evidence. You need to gather the evidence, and some people call it retrospective planning permission, but I think the correct name is certificate of lawful use. That's what you're applying for. You're applying for a certificate of lawful use which regularizes the existing use of a property. And what you need to do is you need to supply evidence that if it's a flat conversion, you need to show 4 continuous years usage as that use. If it's a change of use, you need to show 10 years continuous years evidence. The local authority use a test which they call, it's on the balance of probabilities. So they will accept the evidence that you put forward unless they've got any evidence of their own which contradicts your evidence. And I'll explain a little bit about what that means in a moment. Now, I often get asked what the best forms of evidence are. The best forms of evidence are not the ones that you can knock up on Microsoft Word on your PC. I've got them on a secondary list, and they're not advisable because they're not substantial enough. The best evidence that you can come up with is stuff from third parties, and the best third party is the council itself. I see so many of these flats where there's no planning permission, yet each individual flat has got council tax. If you've got council tax for each individual flat for 4 years, you're virtually home. And the more you can add to that, the better. So EPC certificates are fantastic. If you've got EPC certificates for each individual flat, and the date of the EPC certificate is more than 4 years ago, you're home and dry. Tenancy deposit certificates, utility bills. If you've split the utilities and the services in each individual flat, and you've got separate electric meters with electric bills, you're home and dry. Royal Mail postal records. You can go online and you can look up the postal records of any properties, see whether it's split into the individual dwellings. The electoral roll. I've been down to the local authority to inspect the electoral register. And what I'm looking for is 3 Acacia Avenue, flat number 1, 2, 3, who are the occupants, noting them down, and looking for at least 4 years back records of that. Sworn statements. Now, sworn statements is when someone does basically a written statement, which is done in front of a solicitor, which basically says it's true, and it's the same sort of thing as if you went to court and lied. It would be under the same kind of perjury rules. So sworn statements are a big deal. So let's say you've got a lettings agent who's been managing the property for 5 years. Then he or she can write a sworn statement to say, I've been managing this property for 5 years, it's been 4 self-contained flats during all the time that I've managed it. Sworn statement, signed, witnessed by a solicitor, bang, that's evidence. And land registry records. You can only do this if the property has been unencumbered. Sometimes the previous owner has an unencumbered property with no mortgage on it, and they have created separate land registry records for each of the flats. If that's been done more than 4 years ago, done. Now, these are the best forms of evidence, but you must show 4 sort of continuous years usage to be home and dry. If you've got 2 or 3 of these, that's it, you're done. Lesser forms of evidence are things that you basically knock up, and there's no way of verifying them as such. So you've got things like tenancy agreements, inventories, rental statements from letting agents, or Rightmove rental details and the like. But this is second. If all your evidence is from this list, you won't be successful. You've got to have a few evidences from the first list. Does that make sense to people? Yeah? So when you submit your application, you'll submit your application for lawful use. You'll get someone to do some floor plans of the property. You'll produce some kind of statement outlining your case and referencing the supporting evidence documents that you're going to put forward. And you put that in, and you should get it within 11, 12 weeks. You'll get your certificate of lawful use. Now, what I recommend you do, because different local authorities treat these applications in different ways. So let's say you're looking in Hillingdon or Hounslow or Barnet or whatever. Get onto your local authority's website and do a search on recent planning history, and do a search on certificate of lawful use applications, and see who's applied for these certificates in the past year. And against each application, you will see the case officer's report. I read case officers' reports because they say how they've evaluated each case and how they've measured up to the tests that I've outlined. If you do all that before you buy, you can pretty much guarantee that you're going to get the planning permission regularised. Now, I haven't failed yet to get the planning permission regularised because I go into a purchase knowing what the test is that the council are going to apply, and knowing I've got all the evidence to kind of meet that. I mentioned I was going to give you some reading as well. 2 great books. These are written by QCs and barrister, basically. They are. I mean, I wouldn't read them late at night. I mean, it's a tough read. There's lots of case law and all of that. Planning Enforcement, Bloomsbury Professional, and this one, Planning Law and Practice. Great books, take you through the law, give you plenty of case studies. There's lots of information or detail on the stuff that I've outlined. I've got a time for 1 or 2 questions around what I've said. It's just a bit of a whistle-stop tour through a bit of an interesting strategy. Yeah, Andrew.
Are looking for authorities, would that interfere with getting retrospective planning?
No. That wouldn't interfere with this. The issue is the existing use and showing 4 or 10 years continuous usage.
Yeah. If you had 4 flats that you could prove had existed as flats but hadn't necessarily been used, all of them as flats, so say one of them had been vacant for say 3 years, but you could prove they were converted, is that sufficient?
I've been told that's a grey area because it is not. You see, what I've outlined is what there's absolute case law for, and they can't turn you down on. I've walked away from prospects like the one you described because I understand it's a grey area. It's like one lawyer will tell you, you can argue that because it is a flat, you've got continuous use, but another lawyer can interpret the law saying, well, because you haven't had anyone occupying it, it's not continuous use. So it's a grey area. It can be argued 2 ways, so I tend to stay away from those. What I've tried to describe is what you can only argue one way, and we'll kind of get you through. Yeah.
I've got a few properties like this that fit that. The 2 things, 2 questions are, one is, when you get the certificate of lawfulness, is that enough to get separate mortgages on each flat? And secondly, is there a group of professionals that will assist in this process?
Yes. Yes, if you'll get your certificate of lawfulness, it then has to be minimum size-wise in terms of mortgageability, because most mortgage companies will insist on 25 or 30 square metres of size. Sorry? 30 square metres so as long as each one's over 30 you've got the certificate of lawfulness, that's fine. It's 30 square metre test then, the minimum size. And you're really looking at planning consultants. Now, what I tend to do is, because I look at a number of London boroughs, I go on the council website, I look at who's applied for similar certificate of lawful uses, see who's won, and then there's normally a planning statement submitted with the application. And the consultant who's done that is name and numbers all on the bottom. So I tend to just use the people who have got stuff through in that local authority. So I get it all from the planning website. Yeah.
If you had a property that happened to be a leasehold but was already split into flats and it complied with everything else, would you still need the freeholder's permission to go through this process to get...
If you've got a freeholder involved, you will need their permission, because what you're looking at doing is subdividing a lease. But I would ask you to keep that question for our lease expert after the break. Yeah.
Enforcement notice, game over, or is that somehow overcomable?
It all depends what they're trying to enforce. It depends whether they're trying to... here's a typical scenario. Properties are used as 4 flats. It was converted and has been in continuous use for the last 6 years. So you're over that 4-year limit. Enforcement notice lands. Then you can either comply with the enforcement notice or submit a retrospective planning permission application. So in the scenario I've described, you'd submit a certificate of lawful use, you'd present your evidence for 4 years. The enforcement notice basically goes on hold until they've determined that application. If you've got your 4 years evidence, fine. If not, then the enforcement notice holds. That's how that scenario would, yeah, Pavan.
When you say continuous usage, does that allow for vacant periods in between?
Yes, it's scale and extent. The problem is when it's a 6 months or a year, it's a few days or a week or two, standard letting voids, because you'll be able to show continuous operation, because it was either advertised to let, it was available to let on portals, and it might be empty for 2 weeks in between tenancies. That's okay. Louis?
If you know that you've got utility bills for 4+ years, but generally speaking, obviously the tenants would have had those, and it might be difficult to get, is there a way of actually obtaining that from the utility company? Or?
Utility companies don't tend to care too much, and sometimes they get changed. If they're properties which you own, then I recommend building that into the end of tenancy procedure. So as part of the checkout, you ask them to give them copies of their bills when they check out of the property. Sorry? It is very difficult. What you can do is get something which says when the separate supply was installed. You can get that, which is helpful, but it won't show the continuous use. Okay, I hope that was useful.